In my prior video about legal liabilities of auditors, we talked about who can sue auditors under common law: clients, near-privity third parties, foreseen users, and reasonably foreseeable users. In today's video, we'll continue this topic with the type of claims those plaintiffs can actually make, how serious those claims are, and what defenses auditors may use to defend the case. That said, keep in mind that approximately 95% of all claims brought by clients against the auditor end up getting settled out of court. And one primary reason is that audit firms are typically risk-averse, and cases that settle privately between plaintiff and defendant do little to damage the auditor's reputation. In addition, the SEC also brought fewer enforcement actions against companies, and in 2024, the SEC brought enforcement actions in only 58 cases. Students often think that the auditor's liability depends on only who the plaintiff is, meaning who's suing the auditor, for instance, the client or a third party. But that's only half the story. The type of claim, negligence, gross negligence, reckless conduct, or fraud, often matters more. As claims become more severe, legal barriers like privity matter less, and auditors face broader exposure. Courts view auditor behavior on a continuum, not as a black and white kind of liable or not liable issue. Ordinary negligence involves a failure to exercise due care, and at the far end is fraud, intentional misrepresentation. Between those lie gross negligence and recklessness, which often determine whether third-party claims succeed. Professional negligence, often called accounting malpractice, is the most common claim against auditors. Ordinary negligence for an auditor means that the auditor did not demonstrate the same degree of care, skill, and judgment that a reasonably prudent and competent auditor would under similar circumstances. Courts often ask, what would other competent auditors have done in similar circumstances? An example might be that the auditor followed the same audit plan as the prior year, even though the risk profile of the client had changed since the prior year. A claim for ordinary negligence can typically be brought by those in privity with the auditor or a limited class of foreseeable plaintiffs. To prove a claim of ordinary negligence against an auditor, the plaintiff must establish that 1. The auditor owed a duty to the plaintiff to act with a certain standard of care, adhering to Generally Accepted Auditing Standards or GAS. 2, the auditor failed to meet that standard of care, meaning failed to follow GAS, thus breaching their duty. 3, the auditor's breach was the direct cause, both cause and effect, and proximate cause of the plaintiff's loss. And 4, the plaintiff actually suffered a measurable financial loss or injury as a result of the breach. So duty, breach, causation, and damages. Negligence is not universally available to all plaintiffs. Basically, clients almost always can sue for negligence, whereas third parties must satisfy increasingly demanding legal tests depending on jurisdiction, as developed in cases like ultramarines, credit alliance, and Rouge factors. Gross negligence is one of the most misunderstood concepts in auditing law. Unlike ordinary negligence, which involves a failure to exercise reasonable care, gross negligence reflects an extreme breakdown in professional judgment. Courts often describe it as conduct so careless that it approaches intentional wrongdoing even if actual intent cannot be proven. This is why gross negligence is frequently referred to as constructive fraud. The court is essentially saying the conduct was so egregious that we will treat it as fraudulent, even without evidence that the auditor intended to deceive. A common theme in gross negligence cases is the failure to respond to clear red flags. Things like unexplained journal entries, unsupported management explanations, Weak internal controls combined with aggressive accounting, prior warnings that were ignored or downplayed. At this point on the liability continuum, privity-based offenses begin to weaken significantly. Plaintiffs who cannot sue for ordinary negligence often attempt to elevate their claim by arguing that the auditor's conduct was grossly negligent rather than merely careless. A classic example is State Street Trust Company versus Ernst. In that case, the auditors issued an unqualified opinion on financial statements, knowing that a lender was relying on those statements to make a loan. Shortly afterward, the auditors discovered that receivables had been overstated, but failed to communicate this information to the lender. The client subsequently went bankrupt, and the lender suffered losses. The court held that although there was no evidence of intentional deception, the auditor's conduct amounted to gross negligence. The key language from the court was that a reckless disregard of consequences may take the place of deliberate intention. This case is foundational because it clearly demonstrates that gross negligence can substitute for intent. Fraud liability may exist without proof of actual intent, and auditors cannot ignore known problems once reliance by third parties is foreseeable. Earlier in the presentation, we saw auditor liability described as on a continuum, from negligence at one end to fraud at the other. Recklessness is the pivot point on that continuum. First, recklessness bridges negligence and fraud. Negligence involves failing to recognize a risk that a reasonable auditor should have seen. Recklessness goes further. It involves recognizing the risk and proceeding anyway. Because of that, courts often treat recklessness as a substitute for intent, especially in fraud cases. Second, recklessness weakens privity-based defenses. Ordinary negligence claims often fail when plaintiffs lack privity or near privity, but when plaintiffs can show recklessness, disregard for the truth, courts are much more willing to let claims proceed even for third parties. Third, recklessness expands third-party liability. Many plaintiffs who cannot sue for ordinary negligence try to bring their claims as fraud or constructive fraud by alleging recklessness. This is why recklessness is so strategically important in litigation. Fourth, recklessness triggers regulatory enforcement, particularly in public company audits. For PCAOB regulated audits, recklessness has historically been the threshold for serious sanctions. Even though the PCAOB has recently lowered the threshold to negligence for certain violations, recklessness still leads to more severe penalties, reputational damage, and enforcement consequences. Finally, recklessness signals conscious disregard for risk, which juries and judges respond to very differently than mere carelessness. Auditors are not expected to be perfect, but they are expected to not ignore red flags. Negligence asks whether the auditor made a mistake. Recklessness asks whether the auditor saw the danger and chose to proceed anyways. So in our prior example of an auditor keeping the same audit plan even though the risk profile of the client company changed, might be elevated from ordinary negligence to gross negligence if the risk profile changed significantly. For instance, the revenue doubled, receivables increased significantly, etc. Recklessness would be if the auditor had stuck with the same audit plan even though the board of directors meeting notes, as well as the CEO and CFO communication shared with the auditor, indicated that the financials had changed significantly, that there were concerns about going concern, and the auditor completely ignored the information. That distinction explains why recklessness plays such a powerful role in both private litigation and public enforcement. The plaintiff in the case of gross negligence without intent or with recklessness has a higher bar for proving that the auditor has acted with an extreme departure from reasonable care. They need to show extreme carelessness or intent, which could lead to punitive damages. Recklessness is a step beyond gross negligence, often involving conscious indifference, which could significantly increase potential liability, including punitive damages. Fraud claims are available to all plaintiffs, regardless of privity, and it's the most serious allegation an auditor can face. Fraud occurs when an auditor intentionally misrepresents facts, knowingly issues a false audit opinion, or deliberately ignores information that would reveal the truth. This is not about mistakes or oversight, it's about intentional deception. Courts often use the term scienter, meaning the auditor acted with knowledge or intent to mislead. Plaintiffs must prove false representation, knowledge of falsity, intent to induce reliance or reason to expect reliance, actual reliance, and damages. Unlike negligence-based claims, fraud requires proof of intentional wrongdoing. Fraud differs from lower-level claims such as negligence, gross negligence, and recklessness in a few ways. Negligence is simply failing to exercise reasonable care. Gross negligence is a more extreme version, a major departure from professional standards. Recklessness is even higher. The auditor consciously disregards obvious red flags. Fraud sits at the top of this hierarchy. It requires proof that the auditor knew their statements were false or intentionally created misleading audit work. This is why fraud claims are harder to prove but carry much heavier consequences. A recent example is the 2024 B.F. Borgers fraud case, where the Colorado-based audit firm was involved in a massive fraud case affecting more than 1,500 SEC filings between 2021 and 2023. The allegations included fabricating audit documentation and falsely telling clients their audits complied with PCAOB standards. Based on what I read about this case, the auditors basically just copied the prior year audit files and passed it off as current year audit papers. And that makes this case a good illustration of auditor fraud because the SEC alleges the misconduct was deliberate and systemic, not accidental or negligent. The auditor has several defenses available for each of the claims. In an ordinary negligence claim, the auditor may argue that they did not owe a duty of care to that specific plaintiff, especially if the plaintiff is a third party. The auditor may be able to demonstrate they followed all relevant professional standards, specifically Generally Accepted Auditing Standards and Generally Accepted Accounting Principles, proving they met the required standard of care. The auditor can argue their work was not the cause of the plaintiff's loss. For example, the loss was due to an unforeseeable market downturn, a poor business decision by management, or some other intervening event. And the auditor may assert that the plaintiff was also negligent and contributed to their own losses. For instance, management provided false information to the auditor or failed to maintain adequate internal controls. The auditor can argue the plaintiff did not actually suffer a financial loss or that the claimed damages are speculative or unprovable. And finally, the auditor can rely on the terms defined in the engagement letter, which explicitly outlines the scope and limitations of the audit, potentially showing that the area of loss was outside the scope of the services provided. Most states now apply comparative negligence, allowing damages to be apportioned rather than eliminated. If a client's poor controls contributed to fraud or loss, damages may be reduced, but auditors are not fully excused. Some jurisdictions apply the audit interference rule, limiting what client conduct counts. In the case of gross negligence, the auditor can show evidence that meaningful audit procedures were performed, there were no extreme departures, and there was reasonable reliance on management representations. When the Plaintiff alleges recklessness. The auditor can demonstrate that the auditor did not ignore obvious red flags and that judgment was reasonable or that red flags were not obvious. Now, when it comes to fraud, the auditor can demonstrate that there was no intent, the auditor acted in good faith, and believed that the statements were true at the time. Or another option is to show that the plaintiff did not actually rely on the audit opinion. Legal liability tells us the minimum the profession requires. Ethics asks for more. As future accountants and auditors, your responsibility isn't just to avoid negligence or fraud. It's to uphold the trust that financial reporting depends on. Understanding these claims isn't just about avoiding lawsuits. It's about becoming the kind of professional others can rely on.